Good afternoon, ladies and gentlemen. Good afternoon. Are you well fed? Is everyone fine? Okay, so kindly, it's good to see you back this afternoon. We thank you for staying on. We are going to go straight into the program. This afternoon, we're going to be reflecting on election and legal framework for elections and electoral dispute resolution. With us here, we have from the Judiciary Committee on Elections, we have Honorable Edwin Molochi, who has been accompanied by a colleague of his. We also have ICJ. Yes. We have David Thuku Mburu from ICJ. And Felix Odhiambo, Executive Director for Electoral Law and Governance Institute for Africa. And we also have Katiba Institute. So these are the organizations that are going to be the discussants in this session. I kindly ask you to come forward if you don't mind. Knowledge, we will not have a presentation projected, so I think you can sit here and the projector light will not interfere. So Mr. Felix Owor is going to set us off with a context setting on the legal framework for elections and electoral dispute resolution generally. He's going to give a few remarks, and then after that we can have a presentation from JCE and another presentation from ICJ. Katiba Institute, we have been told you're in the building. Karibu sana. So, Felix, karibu.
Ladies and gentlemen, let me adopt the protocol that was set in the morning. Safe to say good afternoon, everyone. It's usually very, very difficult to have a session after lunch, not just for the participants, but for the presenters alike. And so I will try to make this session as brief as possible, and to limit my interventions just to posing thought-provoking questions. And then my good friends and colleagues who are here, including JC, would then be able to have an opportunity to set or give us the perspective that reflects the work that they have done. But as a starting point, let me see by a show of hand, how many people are watching the ongoing World Cup? I can see majority of those people who have raised their hands are actually men. Ladies, you're not watching World Cup, or your teams have been eliminated. Which team are you supporting? Tanzania? Somebody actually said yes. Tanzania is not playing the World Cup, so that has just confirmed that our sisters are not very keen at the World Cup. But I'll talk about, as Brenda said, to give perspectives and context to the legal framework for elections very briefly, and also to look at the electoral dispute resolution regime in Kenya. And the starting point is that Kenya has held 7 multi-party elections since the country reverted back to multi-party democracy in 91. And we have held as a country three elections since we promulgated the 2010 Constitution. And the fundamental question that has existed is that why is it that 7 elections down the road, and having passed a constitution that was hailed as both transformative and progressive, we still talk about the credibility of elections in this country? And a related question is, if the Constitution of Kenya 2010 was intended to put us into a new framework, how comes after every election year we still talk about the same things? And at what point will we then be able to say that we have matured, or tumefika as a democracy, as some people like to call it? The second point, I think, is to appreciate is that one of the reasons why the 2010 Constitution was hailed as both transformative and progressive was because of how it chose to provide a new framework to manage our elections. Substantial section of the Constitution was devoted to elections. And it wasn't just that. In 2011, we passed a set of election laws that were intended to then strengthen the electoral framework and the electoral process. But despite that, there have been persistent challenges that have continued to recur since the first multi-party election in '92. And I think moving forward, somebody said that insanity is doing the same thing and expecting a different result. I think for us in this sector, and ladies and gentlemen, we'll probably, in this new electoral cycle that has begun, be able to ask some of these very difficult questions. In the just concluded electoral cycle, the problem is we never enacted comprehensive legal reforms. The fate of the country was pegged on BBI. And the expectation was that electoral reforms would be achieved through VBI. But when BBI was dismissed by the court, for the first time since '92, we went to an election that the only tangible amendment that we had was the amendment to the Political Parties Act that was passed in January of 2022. And so these new electoral cycles, I think a comprehensive audit needs to be undertaken with the very serious question being asked, what is it that we can do differently to secure and strengthen the legal framework in this new electoral cycle leading all the way to 2027, and to fix some of the problems and some of the gaps that had been noticed? When we passed 2010 Constitution, the Parliament was expected to pass all the laws related to elections within the first year of the promulgation of the Constitution. The danger there, though, is that whereas Parliament made progress in passing these legislations, and that is how we ended up with the Elections Act of 2011, the IEBC Act of 2011, Political Parties Act of 2011, there were certain laws that were never passed. In other words, the legal regime to operationalize the electoral framework has not been realized to date, at least as was intended to be done by the Constitution. And that is why, even as we speak, the gaps that exist is that there is no law, or at least there is no framework to implement a law that was passed in 2013, and that is the Election Campaign Financing Act. So this is a gap in our legal framework or laws that were intended to be passed within the first year of the promulgation of the Constitution. The other one is the referendum law. For those of you who recall, BBI was partly dismissed because there was no referendum law. Now, This law was expected to be passed in 2011, but unfortunately, as a country, this remains a gap. And then finally, a gap that still exists is that there is no law to guide the country in the boundaries delimitation process. As it were, the first delimitation was guided by a schedule in the IEBC Act, but that act expired or lapsed with the first delimitation exercise in 2012. Kenya is expected to conclude the next boundaries delimitation by the year 2023, and yet there is no legal framework to guide the delimitation exercise. And so this is a gap. Now, we have the 13th Parliament is in place, and when seized with an opportunity to enact the First Amendment, you ought to have expected that the amendment to IEBC Act to provide for a framework for boundaries delimitation would have been prioritized. But instead, the First Amendment was actually on the selection of the new IEBC commissioners. So I think this is something that you really need to flag, and we really need to flag out. In terms of reforms, what do we need to do? Or what do we need to consider in the next few weeks in this new electoral cycle? Number one is the weakest link in our electoral or consolidation of electoral democracy, and that is on election management and administration. And to this end, I think the Supreme Court did some work made our work a bit easier by making recommendations in their judgment to deal with the issues of leadership, but also to deal with issues of corporate governance. Why this is an issue is this. Since '92, we've held 7 elections, with the election expected in 2027 to be the 8th multi-party election. But the surprising thing is that we have also changed electoral commission in terms of their outlook and composition 7 times. We started with the Chesoni Commission, then the Kivuitu Commission, then the IPPG Commission, then IIEC that managed the 2010 referendum, then Amedizak IEBC, that was the 6th, Chebukati IEBC actually was the 6th. And then in 2022, the composition of the IEBC was changed, and that is how we brought in the 4 commissioners. Now the danger is that as we approach the 8th multi-party election, we will again change the electoral commission for the 8th time. So we change every commission with every election. And I think it should be apparent to everybody in this country that changing the electoral commission by itself does not necessarily guarantee credible elections. Then the second issue would be voter registration. There would have to be serious reforms in that, and the KPMG audit is a starting point. And then the final is results management. This has been a problem in every election, and it has everything to do with the whole chain of result flow. Counting, tabulation, transmission, and declaration of results. It is an issue in our every election, and I think remain the elephant in the room. And I think if we are to move to 2027, we have to get this right. Now, let me conclude with the judiciary, or the electoral dispute resolution regime, and then my good friend Muloshi will talk at length about this. One is that we need to appreciate that we have 2 regimes of electoral dispute resolution. At the pre-election dispute stage, where the political parties dispute tribunal has jurisdiction, we also have political parties' internal disciplinary processes, and then we have IEBC hearing or entertaining disputes with respect to nomination disputes. Now, then, with respect to 2022, and I think Mule alluded to this, I think in terms of approaching this election, that electoral cycle we've just concluded, the judiciary as an electoral institution was probably the most prepared. Numerous trainings were done. I think Mule projected that. I don't want to talk about it. At Algiers, we were privileged to be part of that training and working very closely with JCE from training of the magistrates all the way to the Supreme Court. And at the Supreme Court level, we even invited judiciaries from other jurisdiction. There were, the judiciary introduced technology that not only help within the COVID pandemic situation, but also help in case management. The judiciary finalized the bench book, and right now, as the judges are sitting, that bench book is sort of guiding guiding them through asking the relevant question with respect to EDR processes. But I want to pose two questions and the good thing with our judiciary is they are open to discussion. They are open to constructive discussion about some of the emerging issues with respect to electoral dispute resolution. And I will restrict this to just two things. One, looking at the just concluded presidential disputes. And I posed this question during an ICJ conference in Arusha just last week. There was a lot that was said about the language of the court. And I've had some reflection over this. In Kenya, and by the way, there are only two Supreme Courts in the continent that have invalidated a presidential election. The Kenyan Supreme Court in 2017 and the Malawi Supreme Court in 2020. Now, the Malawi Supreme Court, their decision that came after the Kenyan Supreme Court, agreed with the Kenyan Supreme Court on every legal issue except for one, the standard of proof. In Kenya, the Supreme Court has pitched the standard of proof to what is called an intermediate standard. In other words, it's higher than the civil standard on the balance of probabilities, but below the criminal standard. The Kenyan Supreme Court pitched it higher. The effect of this is that it becomes so difficult for a petitioner to prove problems or challenges in an election petition. Now, the Supreme Court of Malawi disagreed with the Kenyan Supreme Court that if you apply a human rights perspective, and if you consider issues of access to justice, then you cannot impose on a petitioner a higher standard of proof beyond what is in the civil standard. And this is what I normally challenge, and of late, whereas personally I was in agreement with the Kenyan Supreme Court on this singular issue, increasingly looking at the reasoning of the Malawi Supreme Court, I think the Malawi Supreme Court is right. And so this, I think, would be a conversation, and we have begun this conversation with our judiciary. And thank God that our judiciary is willing to entertain this kind of discussions. The second issue is the timeline for resolution of presidential dispute. Ladies and gentlemen, our constitution provides for only 14 days. Is this sufficient given the experience that we have had in the past? And I think this is something that is food for thought for the judiciary in terms of EDR. Not just judiciary, Parliament should consider this, because ultimately it will be Parliament to amend that. Finally, is on the pre-election dispute. The Independent Electoral and Boundaries Commission has jurisdiction to entertain disputes arising from party primaries. The party primaries are conducted by IEBC returning officers. If you remember the situation, the Sakaja case, for example. I think moving forward as a country and as a reform issue, we must begin to interrogate the question whether this jurisdiction is misplaced. How can IEBC conduct primaries and then sit in judgment on the decision of its own returning officers? And I think these are just food for thought, and I think these are some of the things that we need to deliberate and consider in future. Thank you very much, ladies and gentlemen. I apologize if I took longer.
Thank you so much, Felix. Are we able to give him a better round of applause, please? Thank you. Allow me to recognize the presence of Honorable Lydia from the judiciary. Karibu sana. So of course, Mlochi is here, but in plenary, if we have more questions, of course, we have Honorable Lydia Mbacho in the room as well. I also would like to take this opportunity to introduce my senior in many rights, Honorable, najua atanichapa. Yeah, I would like to introduce the moderator for this afternoon session. His name is Francis Angela, a father of many, a teacher to many. So maybe he can just wave so that watu wamwone. Karibu sana. So this is his session. He's going to take over right after the next speaker. Thank you. Honorable Mulochi, the floor is yours. Karibu.
Okay, good afternoon. I adopt the protocol as earlier stated by earlier speakers. My name is Mulochi Edwin. I'm from the judiciary, as you've heard. And I've looked at the program. We are supposed to say something about dispute resolution by the judiciary. And I think most of the things that Felix has already alluded to are things that touch on that area of dispute resolution. The judiciary is right at the center of dispute resolution in electoral disputes. And in that regard, we have a committee under the office of the Chief Justice, known as the Judiciary Committee on Elections, in short, JCE. Initially, it was an ad hoc committee formed by Chief Justice Emeritus Mutunga, and the rationale behind the establishment of that committee was the controversy surrounding elections. You remember in 2007 when Raila Odinga lost elections, lost in courts, there are people who suggested they should go to court. But then they said we will not go to courts that are manned by the government of the day. So there was no confidence in the judiciary whatsoever when it comes to resolution of disputes. And those who were in the judiciary by then, and even after the 2010 constitution was promulgated, reached a decision that we need to do something about the image of the judiciary. So part of the reforms that were put in place, or part of the decisions that were made, was the establishment of this committee. But then when Chief Justice Maranga took over, it was concluded that this is a very critical committee which needs to be a permanent committee. And that's why now it morphed into JCE as a permanent committee in the office of the Chief Justice. This committee, it draws membership right from the Supreme Court. It's chaired by Justice Mohamed Ibrahim of the Supreme Court. The vice chair is Justice Daniel Musinga, the president of the Court of Appeal. We also have Justice Mokin Wanjala is part of this committee. We have other judges of the High Court. We have Justice Kathurima Thoinoti. We have magistrates. My sister Lydia Mbacho here is a member representing the magistracy. And other members from the judiciary. And even we have a counsel and a consultant, Felix Owor, who has been very, very, very helpful to this committee. Briefly, just allow me to tell you about our mandate. We advise the judiciary on the administrative arrangements and measures for the efficient disposal of election-related disputes. We also develop and implement a training program for judicial officers, judges, and judicial staff in preparation for EDR, election dispute resolution, among other roles that we play. Time will not allow me to go into all of them. Now, in preparation for the 2022 election cycle, we conducted a series of trainings with support from various players like Felix and Elgia. They were so helpful to the judiciary. Brenda is here, I've seen Sabrina. These are very kind people who've worked with JCE. IFES, I've seen Lamin, they have worked with JCE, and many other supporters for whom we are so grateful. So we had trainings, around 13 trainings. We trained all the judges of the Supreme Court and their staff. We trained in preparation for resolution of electoral disputes. We trained judges of the Court of Appeal and their law clerks. We trained 68 judges of the High Court. We trained 342 magistrates. We trained 63 registrars of the High Court. We trained 119 ICT officers and even court assistants and court administrators in preparation for this election. Now, apart from the trainings, which were intense, and in these trainings we involved other key stakeholders in the electoral system like IEBC, the police, ODPP, and all these other players in the electoral system. They were all involved just in preparation for resolution of election disputes. Apart from that, we also worked on a bench book. A bench book is a very critical resource for judges and magistrates and even lawyers in private practice. This book contains jurisprudence, past decisions on the area of elections, and as you know, we call it the principle of stare decisis. I don't know whether I'm pronouncing it right, Brenda, but you'll correct me. So this book contains those cases and other relevant information that guides judges and magistrates in making decisions in electoral disputes. We also did frequently asked questions. That was a document, and if you look at that document, even if you don't know what to do when it comes to filing an election petition, you are sure to be guided right and well. We also had standard operating procedures, which were also prepared by JCE with support from our friends, as I've enumerated, and many others that time may not allow me to mention. All these geared towards preparation for EDR. We also did something that I remember meeting an election observer from the US, and she was so awed by the e-filing. I don't know how true it is. I've not been to the US, and she was telling me, this one, you've even beaten us. So more than 99% of election petitions were filed online this time round. And this was the first time this was happening. It's just in a few areas that people still filed them manually, but those are issues that are being addressed. So it's a system that JCE worked on with support from donors, and we were able to realize like 99% that all these matters were filed online. And then also in preparation for EDR, once the election petitions were filed, we had 125 election petitions in total, and we attribute this to the decision by the Supreme Court, because people normally wait. In 2017, the moment the Supreme Court nullified the election, we had a flood of petitions coming in for governor, for MP, for women rep, for MCS. They went all the way to 388. But now, this time round, by the time the Supreme Court was dealing with the presidential petition, we just had around 22, 23 county petitions and parliamentary petitions. So the moment the Supreme Court upheld the current president's election, dismissed the petition, people were discouraged. So we only had up to 125 of them. And out of this 125, Already 33 have been concluded. Some have been withdrawn, some have been dismissed on technicalities. We only have less than 100 that are still in the system. Either hearing is ongoing or they are pending judgment. That is the position. But then remember, we also had the party lists. We had a total of 85. These were filed after gazettement of the nominees. Those who are nominated for either MCA or MP or those other seats or senator. We had 85. 8 have already been concluded, either through withdrawals or dismissals, and the others at various stages. So that was the number. And then remember, there is also PPDT. Felix has already mentioned. Once party primaries are held and maybe one of the contestants is dissatisfied with the outcome, of course they first go to the internal dispute resolution mechanisms of the parties, and then if they are not satisfied, they still go to the PPDT. And this time round, unlike before, PPDT was decentralized. We had PPDT sitting in 8 places. Nairobi had A and B. We had one in Kisumu. We had another one in Kakamega. We had another one in Mombasa. We had another one in Meru. Another one in Eldoret. That makes it 8. So when these disputes went now to PPDT, and remember PPDT had also gone online, they were able to resolve 318 appeals. And they are concluded as we speak right now, 318. So that is also something that was done in preparation for EDR, and I believe the judiciary deserves a clap for that. Yeah, so now currently, if I were to speak briefly about what we are doing now, as I mentioned, the petitions and party lists, applications and matters are ongoing. We are already below 100 because, as I said, 33 and 8 have already been concluded, either through withdrawals or dismissals or other means. So we are now monitoring, which is part of our mandate as JCE. We are now monitoring and evaluating the management and administration of those disputes as resolution goes on in our courts of law. That's what we are doing currently as a JCE. And after that, we will prepare a report which we will share with our stakeholders. Now, we also made some observations as I conclude, which we believe are long overdue. Number one, you will remember just before elections, the chair IEBC went before cameras and said, because of cases that are still pending in court, we will have to postpone elections in some part of this country. And that is something that really disturbed her ladyship, the Chief Justice. And I remember she summoned a meeting and she was like, we are the one who seems to be giving this thing a bad name. We have to do something about it. But you'll remember, even after the Dispute Resolution Committee of IEBC rendered decisions in some of the matters that went there for resolution, people were filing cases as late as a day, 2 days, 3 days before the election. Yet, the judiciary is being blamed for delaying cases. So we believe, just as we have timelines for election disputes, there is need to have some arrangement anchored in the law, whereby we should have timelines within which someone can move to the DRC, that is Dispute Resolution Committee of the IEBC, timelines within which the DRC is supposed to render a decision, and timelines within which any dissatisfied person should move to the High Court to appeal the decision of the DRC, Dispute Resolution Committee. We believe that will stave off much confusion that comes around the time of elections. We know we are a litigious country, but it doesn't do us good when we are filing cases as late as a day before elections. The other observation that I have made, and Felix has mentioned the gaps in the law, but there's also some observation that we've made as JCE. When it comes to appeals, you know, the magistrate court deals with petitions with regard to the member of county assembly. And then the parliamentary seats, disputes with regard to the parliamentary seats go to the High Court. Now, we all know that if someone who filed an MCA, a petition with regard to an MCA seat, is not satisfied with the decision of the court, they have a right to appeal to the High Court. And you'll find that at Section 75 of the Elections Act. When the High Court makes a decision and in an election petition and the party is dissatisfied, they have recourse. They can appeal to the Court of Appeal. And we know the timelines. You are supposed to appeal within 30 days of the decision being rendered. And if it's either the High Court or the Court of Appeal, they have 6 months within which they should hear and determine that appeal. Now, if you look at Section 85A of the Elections Act, it's very clear. Once a party in a matter that has been heard and determined by the High Court files an appeal with the Court of Appeal, that appeal acts as automatic stay of the certificate of election that had been given by the High Court. But now, when you come to Section 75 of the Elections Act with regard to appeals from the magistracy to the High Court, it is not, yes, it just says a party can move to the High Court if not satisfied, can lodge up an appeal in the High Court. But it doesn't state whether that appeal acts as automatic stay of the certificate that has been issued by the magistracy. So apart from the big gaps that Felix has alluded to, we believe also within the laws themselves, there is need also to relook at the electoral legal regime or legal framework and ensure that we seal some of those parts of some of those lacuna in our law. And then the issue of campaign financing, I heard Musau Mule alluding to it. It's a big issue in this country. And it's actually one of the contributors to the sleaze, to the graft in our country. Because people spend a fortune. You hear someone has spent hundreds of millions of shillings. And even for the 5 years he'll be in parliament, the salary that he earns cannot recoup even half of what they have spent. But people will do anything. They will spend an arm and a leg to get to parliament. And when they get there, of course, it goes without saying, they'll find they will do everything within their ability to ensure that they recoup what they lost. So this is one of the contributors to corruption in our country. And we know the vast majority of these people are averse to the passing of this law. And I know the civil society your voice is always heard. It is something that we must really do something about. Because this law was to be passed long ago, but they have ensured that it doesn't go through. I believe as time goes by, something will be done. So I want to believe I've said something. Thank you so much for your time.
Perfect. So first off, thank you, Brenda, for the glowing introduction. Maybe you have been in a science. I'm not sure the title of honorable fits, but I will claim it. I am many things to many people. My name is Francis Ayua. Some people prefer to call me Angila. Angila is my middle name. That fits the bill. That's fine. If you meet my colleague Fred Oedi, I'll probably tell you this is the senior adjunct elections advisor. If you meet the rest of my clients, they just know me as a governance consultant. But the best introductions are usually by the guys in my local. They just call me Wakili. So let's continue. The rest of this session, I think, has got one more presenter, and in short order, we'll be calling them up. And then after those three presenters, we are going to have two discussants. So my typical role with these things is also to ration time, because my duty is to make sure that we cover everything that was intended for today. So Dudley, there's no discrimination on your part, but when you come up, please do 10 minutes of what you have to say, and then we'll see how we can ration time for everybody else, so that we achieve both the substance of what I think all of us are here to listen to and to contribute to, but we also follow procedure so that at least those who are on that side are also able to ask some questions or to make some comments based on what has been said. So Dudley Ochiel is the Senior Litigation Counsel at Katiba Institute. He's going to be next, and then we'll take over from there. Thuku, you are a discussant. Where's Dudley? Thank you. I think Thuku must have figured Niko na Makengeza, because I was looking at him while I was talking about Dudley. You know, Brenda, there's that song, what is it called? The one by Busy Signal. It's reggae music again. You and I have some things to talk about. Dudley, welcome. In the old days, before we did this, we made sure the panel was seated here and the moderator knew all his panelists. So nice to make your acquaintance again. Your name precedes you, but I'm sure I would have passed you on the streets. Welcome, Dudley. So you've got 10 minutes, and then we'll go to the discussants.
I'll punish myself by doing about 6 minutes or so, and give you back 4 minutes.
Thank you.
So I'm here to represent Ms. Christine Nkonge, the Executive Director of Katiba Institute. And Francis Ayua, there's something you wrote a while back about standard of proof in election petitions. I read it. It's still an issue that goes on. It goes on because of the stance that JCE, I see Honorable Mulochi is here, and the Supreme Court has taken. In 2013, our Section 87 of the Elections Act said that at the end of the petition, the court shall determine if any election offense has been proved, and the names and persons of the people proved guilty. Proof of guilt. Proof of an offense. There's a criminal angle to that, isn't there? Yes. So the court said in 2013 that because of that, the standard of proof demanded is above balance of probabilities. You must prove that it's more likely than not that something happened. In fact, it said that for those criminal offenses, the proof is beyond reasonable doubt, because there was that quasi-criminal element, there were consequences that would come with that, and there were penalties that would be imposed. But then in 2013, yes, Wetangula was proved guilty of an election offense. He'd given some money at Friends Church Kandui to the people gathered there. The matter went to the Court of Appeal, which affirmed the finding of guilt, and it went to the Supreme Court. But then the Supreme Court says, no, wait a moment. If during this petition, someone is proved guilty beyond reasonable doubt, then what will happen when the report is made to the DPP, the matter is investigated, and it goes down to the magistrate court for the criminal trial, because it has two elements. It has the element of disturbing the integrity of the election, and then it has a criminal element where someone bears responsibility for that culpability. So the Supreme Court orders Parliament to separate those two elements, to separate the civil element that is invoked in a petition, the element that pollutes an election and makes it not free and fair and renders it void, from the element where someone bears criminal responsibility. And Parliament did that. In 2016, you remember the Kiraitu Orengo bipartisan reforms? It edited the Elections Act. It removed all offenses from the Elections Act, except one, which is double registration as a voter. But that is not the kind of offense that you'll find pleaded in a petition. In 2017, I recall Paul Mwangi urging the Supreme Court to depart from the initial standard of proof it had set, saying that this intermediate standard does no use. The proof beyond reasonable doubt makes it difficult to prove electoral infractions. But the Supreme Court said, no, we've already said before in 2013 that you must prove to the intermediate standard, and in some cases, if you allege an offense, beyond reasonable doubt. In 2022, the LSK and ICJ went to the Supreme Court one more time and told it that, no, look, there's an issue here. The jurisdictions that retain the intermediate standard or that demand the high threshold of proof have it for a purpose. They still have a criminal jurisdiction. At the end of the petition, in India, in the UK, you can be sentenced. There's that element of finding of guilt in those jurisdictions. We don't have that in Kenya. And if the Supreme Court finds someone guilty, then what happens to them when they go to the magistrate's court? Or why should the report be made to the DPP to investigate? What will the DPP be investigating? There's an issue there that we still need to look at. And also, remember that the election petition, especially the presidential one, is heard in about 3 days. The court has a combined 14 days. The first 7 go to case management, responses and things like that, interlocutory applications. The court then sits within about 3 days, the first day for the petitioner, the second for respondents, and then the third day is rejoinder and people like amicus, if they're allowed to speak. While under the Election Offences Act, the DPP has 2 years. So you want a petitioner to prove in about 3 days using paper evidence, affidavits, not a single witness, the same thing that the law allows the DPP to prove in 2 years. That speaks to the aspect of equality. So the issue of standard of proof, Honorable Mulochi, still needs us to look at it again. And I hope that institutions like ICJ and LSK will still be willing to raise it. On the issue of our electoral legal framework, as I move to conclude, I think that there's a bit of blame that everyone bears. On the gender question, the judiciary bears the blame, I think, completely. When the High Court bench was about to deliver its judgment on whether Parliament was lawfully composed because of the failure to honor the 2/3 gender rule, the Court of Appeal had a slim fit stay. Slim fit because there were about 10 or so parties in court, but National Assembly took as a single issue to the Court of Appeal, excluded the rest of the parties, the likes of FIDA, Law Society of Kenya, Katiba Crew, and the Court of Appeal, without, interrogating where the other parties were, issued a stay in that slim fit application taken to it. The main appeal was never filed, never needed to be filed, it has never been heard. Again, when IBC said that political parties must bring compliant lists, it's the High Court which excused it, said that no, this thing was not participatory, although IBC brought evidence that it had engaged political parties for many years behind. I would say the same of election offenses, the High Court holding that the IBC has no jurisdiction to enforce the Electoral Code of Conduct. And maybe something as well about the campaign finance. I would blame both Parliament and the judiciary. The judiciary allowed Parliament to get away with failure to enact the campaign finance regulations. Thank you, Francis, for the opportunity to speak.
Thank you very much, Dudley. In the world of this sort of thing, I think you would be due an award for time management, and I think everybody else has taken note. Quite some pithy things, but I will come to those later. For now, allow me to recognize the presence of Catherine Mutanu, our very own colleague in the struggle. You knew I wasn't going to miss this. Who is now a CEC in the Machakos County and a comrade in civil society, Joshua would say, just wave. So now you see why we must have a plenary, because watu hawezi kuja wanakaa upande huu na wasemi kitu, si ndio? Good. So I'll give Thuku, who's the first discussant, 5 minutes. To say some things in response to what has been said so far, and to add some of his own. Thuku.
Thank you, Senior. Good afternoon, everyone. Allow me to ride on the protocol that was established earlier on in the day, and also I'll try to be very brief. The church I attend to, the preacher last time said that a good sermon is like a miniskirt, short enough to cover the essentials, short enough to catch your attention, and long enough to cover the essentials. This panel has discussed very weighty issues, and I will not want to dilute what they've discussed, because what they've discussed is similarly, they've picked out my thoughts. Dudley, you are lucky enough I didn't speak before you, because I was just about to speak on the issue of standard of proof, which Dudley has explained very well. I think something else that we also used to say when I was a university student is that you cannot fatten a cow on the eve of the market day. You cannot read for an exam and expect to pass that exam the next day. I just want to briefly speak on presidential timelines and how we settle the issue of presidential petitions in our country. And Dudley has also emphasized on that. 14 days is simply not enough. And as civil society, I think this is a good entry point for us to get into now serious advocacy into moving that 14 days is not sufficient. We are moving from a time that was rife with technicalities. In 1992, in the Matiba versus Moi case, Matiba goes to court, nothing is done. Moi is actually sworn in as president as they wait a determination. An election that was held on the 29th of December was actually settled on the 19th of November the next year. So we are moving away from that. Now we have expeditious super timelines, 14 days, for 7 judges to have gone through a whole lorry of evidence. It's not sufficient. That is the message that I just wanted to, I think, emphasize on. Other issues that have been mentioned is the endless commercialization of politics in Africa. We need to enact the Campaign Financing Act. Again, it's already in place. Operationalization has stalled. This is something that, again, as civil society, we need to get into. EDR, unlike any other process that is in the electoral process, has not received the attention that it deserves. Electoral dispute resolution still remains the one thing that Kenyans are not aware of. Kenyans are aware, have been made aware of the civic education. You need to register, you need to participate in the vote, but the electoral dispute resolution still remains foreign to the minds of Kenyans. And I'm happy to say that organizations like ICJ, where I work, and just recently the judiciary through the bench book have been able to start documenting these processes. Those of you who can access the internet, you can access our electoral compendium on our website and get to understand how EDR processes work and how they are handled. I think we also need legislation on access to information, something that Felix also mentioned. The KMPG audit, it revealed findings that I would also call revolutionary in nature. We were told that certain people had access to our system because that is what the KMPG report revealed. This was done on the 3rd of August, just 5 days to the election. Only 47 pages of that report were released to us. A report that had 157 pages. What is the content of the 109 pages? Do we know about that content? Why wasn't it released to us? Access to information is somewhere we need to strengthen our advocacy on. As I conclude by saying that poorly managed elections can be a source of grave public anger, and where the judiciary and also other systems cannot be trusted to resolve the disputes, they can be socially cataclysmic, as was the case in 2007. Mutunga also said that nothing can imperil our democracy more than electoral processes that are contaminated by bias, infected with incompetence, and afflicted by a virulent virus of minimal public accountability. Therefore, the judiciary and other electoral agencies need to demonstrate competence, impartiality, fairness, and remarkably high sense of accountability to the public. Thank you.
Thank you very much, Tuku. I think you are a prime contender for the Time Management Award as well. And I think you have persuaded enough people to join your church. Okay, next we have Dr. Jacob Otachi, who is representing the CEO of the Kenya Law Reform Commission. Jacob?
Thank you very much for the opportunity to speak. As mentioned, I represent the Kenya Law Reform Commission CEO. I'm not going to speak the way my colleagues in the civil society have spoken, because in government, there's a way we speak. But I'm not saying anything about civil society. I used to be in civil society before, so I understand very well. Law reform is actually a moving target. I say so confidently because you can be today discussing a matter that tomorrow completely changes. So the essence of the Kenya Law Reform Commission is therefore to ensure that all the law of Kenya, both at the national level and at the county level, conform to the spirit and the letter of the Constitution. Since morning, I've heard about the letter and the spirit about the election management in Kenya, so I will not go into that. The requirement today was to have a discussion about the elections of 2022 and the ADR. But I want to mention something which was mentioned, I think, by Felix in the presentation he made, that out of the 5th schedule legislation that were required to implement the 2010 Constitution, only 2 have not been passed by Parliament. And I say so because early in the morning, the chair of the NGEC mentioned the gender bill. But I want to mention that in conformity with the requirement of the 2010 Constitution, we as the Kenya Law Reform Commission, the Office of the Attorney General, and the Commission for the Implementation of the Constitution, the defunct, the Nyashai Commission, actually developed all the required bills that were required to be tabled in Parliament. The process at the parliamentary level is a totally different process. So from our part, we have these laws, like the gender bill, which of course is a challenge to all of us, and especially to civil society, to be able to push through so that some of this legislation are actually passed. I want to mention something which I again say it's a moving target, because I have had discussions about the use of technology. Should we go manual or should we have a complementary system? Section 44, of course, there is need for a complementary system. And I wonder, in the just concluded, Mheshimiwa, US elections, people were voting through ballot, rather address, postal address. You send your vote and say to Kenya Postal Corporation, you are certain that your vote is going to be counted, and it will actually be credible. The outcome is going to be credible. How many of us, by show of hands, are willing to have a postal system of voting? Yes, postal, right? Like postal, yes, Kenya Postal Corporation. Absolutely, I can see 2-3 hands. So there's something we say in law. I'm a lawyer myself. There's something we say in law. You can develop a very good law, but if there is no trust in the persons implementing that particular law or legislation, then you have a serious challenge. That's why during the observation at the Bomas of Kenya, anyone who would enter in with a weird laptop, they would be chased out. So the question of trust is not something we can achieve in law, but as we proceed towards the 2022 and rather 2027 general election, we can work around building trust amongst the institutions, especially the institutions that enhance our electoral processes. The second issue I want to raise, which has been mentioned, still on technology, the Kenyans on Twitter, I'm told they're known as #KOT on Twitter, actually had various verdicts. They had already collected the evidence, they had cross-examined witnesses, they had made a judgment, and they had even declared the outcome, isn't it? So in this era of the information superhighway, we need to find a way, especially to be able to have a peaceful election, how we can be able to have a proper way of sharing information from credible sources. I'm even told that media houses tried to tally the vote, but they did not manage to fully declare the outcome. But other agencies out there were able to finally push that out. So there is a social media bill. I don't know how far it is, but I know it was drafted somewhere. It's something the civil society and us as stakeholders in the electoral management process could be able to fast track, so that then we have a regulatory regime within the social media space, because it's actually seeming to have a lot of influence on election management in Kenya. I want to mention something with regards to yes. It has been stated in the morning, and I'm lucky that I happened to have been one of the persons who are seated behind the TV. How many of us, I know most of us did during the Supreme Court decision, rather the petition, all that process. The question of the processes, you remember the Maraga decision, put a lot of emphasis on the process, isn't it? That election is not just an event, it must be a process. You must be able to show that you followed a proper process, including sometimes, as the Kenya Law Reform Commission, we sit at the center or the periphery with regards to implementing some of the decisions that come out. We have on one occasion, thank you, we have on one occasion received references from the judiciary with regards to reform of the law. So we continue to collaborate, and we also receive a request from ministries, departments, and agencies to be able to reform certain branches of the law. I want to mention something about access to information. I think there are regulations which are ongoing. They are yet to go to Parliament. I think it's something which civil society can pick up and see on how we can be able to implement. Very, very finally, because I have 2 minutes, the Leadership and Integrity Act, there still need to be able to strengthen that particular law so that we have then persons who are credible running for our elections. The other issue is that There was a study which was conducted in 2018, and there's a constituency of persons who actually participate in our elections, but we seem to have them not fully supported, known as the intersex persons. So we need to have, in the legal regime, having a framework where intersex persons could be properly identified and participate in the electoral process. I want to donate the remaining 1 minute to the speaker. Thank you very much. I appreciate it.
Thank you very much, Jacob. And Jacob, please come and sit here. I think you've read the Bible. Okay, so we would have been finished at that stage, but I've been alerted to the fact that Philip Gichana of Mzalendo Trust had also been listed as a discussant and is here. Philip, where are you? Yeah, 5 minutes.
All protocols observed. Ladies and gentlemen, good afternoon. Hamjambo tena. You can see some just behind there looking very tired. So I fully understand. Anyway, my name is Philip Nyokundi Gichana. I'm representing our director, Caroline Njiri. And it's very unfortunate that I have this opportunity right now. I was really hoping that the moderator was forgetting about this so that we move on quickly. Because I have to speak after my seniors here. I have to speak after my classmate, Mlochi here has spoken, who's an expert in this area. So I wouldn't want to touch what they have, discussed. But mine would be just on the issue of just reflections. I think, and for me it will be more of questions that I won't give answers, so don't go looking for me outside there for answers. I don't have any, so we have to agree that we will think them through. One, I wish to go back to the issue of policy and legislative reforms in this country, and maybe at this point pose a question. I know we've talked about the trust and us as Kenyans legislating on trust, but just as a question, how many of you feel like we are tired, we should stop legislating this election framework? Yes? And those ones who believe that we should continue legislating until we respect each other? Yeah? We should continue legislating until we respect each other, right? Okay. I am torn in between. But I strongly feel that there is still, for us, a room to legislate and put a few things in order. And I believe it is incremental. As we speak in the last election, and shockingly, I wish IBC was here, I wanted to adopt the Dudley Ocheng style where you just point and say, judiciary, you did us wrong in this election, so we have to point it out. So Mlochi, you'll forgive me. But then, for example, let me ask, IBC, during its presentation at the Justice Legal Affairs Committee, made a very damning observation that yes, they had a number of regulations. In fact, there were almost 5 regulations that they sought to have amended. And when they were doing this was in June, around June. When did we do our election? Yeah? So what opportunity were they giving Parliament at this point when presenting this election regulations amendment? What opportunity were they giving Parliament? So is it possible that Parliament could have adequately sat and considered this kind of regulations 3 months into an election? Is it possible? So it wasn't possible. So they had a number of, regulations. I think they were touching on party nominations and party list. They had regulations on technology. And a number of them, those are very critical, very critical issues going into an election. But then, of course, they are not here. They could have maybe answered us on this one, but they are not here. I wish just to briefly also talk about the election campaign financing. I know it has been spoken a lot. It's almost a broken record. But let me just say this. It is not by default that we don't have this election campaign financing act working. In the last election, we had two bills that were being considered, both at the National Assembly, and that one was by, I think, Jeremiah Kioni. He did an election campaign financing amendment act. We also had at the Senate a similar, but also with different proposals on how to ensure that we have a proper regulatory framework. But then these things also did not happen to work. So my question has always been, what is the future of election campaign financing? Because for sure, the Constitution states that IBC should regulate election campaign financing in Kenya. Who do we have to send home? Do we have to send the whole parliament home? Or do we also have to send the whole judiciary home, with Molochi sitting here, and fix this issue of election campaign financing? So that is another deliberation that we had. The other one, I just also wish to speak on those amendments that saw the light of day. And Felix has spoken about the Political Party Amendment Act. And I just wish to go back to this Political Parties Amendment Act. Of course, the way it was done, we had a lot of issues and the push and pulls here and there before it was adopted. But just fast forward, who remembers Wetangula's ruling or judgment when it comes to the issue of minority and majority in the House? Ladies and gentlemen, you didn't see that judgment? Or you found it perfectly okay? Was it worth praising? Yeah, so there are some issues that we should reflect upon on this issue of the Political Parties Amendment Bill and what it brought us, especially looking at the issue of post-election, coalition agreements that are entered. Because for sure, going into an election and after election, we don't need a judgment to tell us really who is the majority and who is the minority. Do we need? We should just count and say we know the majority and Thank you very much. So that is something else. I wish also to just highlight one, the second last thing I wanted to highlight is also the issue of the Election Amendment Bill 2021. That Honorable Kipchumba Murkomen, together with Senator Ledama, had proposals to amend the issue of the educational qualifications. As we speak, that started from Parliament, and quickly the judiciary picked it up, and before we could realize, now there are no educational qualifications. If you need to be a member of an MCA, if you need to be a member of Parliament, a senator, and even lastly, the governor. So are we heading on the right trajectory on this one? Yeah, we are doing very well? I will let you answer that one. But let me just also highlight one other thing. And Felix spoke about the issue of the voter register. It has always been a contentious issue every time we head into an election. I know organizations here, I think Katiba went to court about the voter register, and a number of them have gone to court. I've heard also that right now IBC is likely to be embarking on developing a clean register. Felix, will you confirm that? I think they are now planning to have a new voter register for 2027. I just wish to highlight that there are few things that come into my mind. I won't touch on the sections, but I will say that after, thank you very much, I'll be, yeah. After the elections, after an audit, for example, the audit that was done by KPMG, IBC is required to table this audit report to the Justice and Legal Affairs Committee, right? The question is, what time does IBC have an opportunity to table this report to the Justice and Legal Affairs Committee under the Elections Act? When was that register was released? 1 month into an election? Around a month into an election. That time, there's no parliament sitting. So are we doing ourselves justice in terms of looking at that register and knowing if the audit has been fully implemented? Are we doing ourselves justice? We will also answer that one. But mine is also just a reflection on 2022, just going into an election. And my question has always been, maybe IBC would have been here, could have been able to answer me. Why is it that we have a very fractured relationship between IBC and Parliament when it comes to during the time of elections? Yeah, so that it is always a push and pull. What IBC threatens this with the capping, and Parliament, comes up and says, we're not going to give you money to carry out an election. So why is this fighting for IBC and elections when I think we're all working towards the same goal as having a fair and credible elections? Why can't the two institutions work together for prosperity? I will wish to end there and donate 1 minute of my time. Thank you very much.
So there you have it. We have quite the panel. I don't know if this, let's get this out of the way. Thank you. So we are not doing very well on time, but I promised, because we are here to talk as colleagues. So you've heard from your colleagues on this end. I think there's typically either questions or comments. If we can have those very quickly, and for each person, I think it is fair to ration it and just say, from all the notes you've taken, ask your most important question or make your one most important comment. Is that fair enough? Good. So let me see by a show of hands how many people have something to say. Yours is a question. Just wait. We're still managing process. We'll come to it. By a show of hands? Good. If it's those three, where's the other mic? Good. Just give her the mic.
Okay, I wanted to speak before I proceed because it's not really a question, but since we are talking about equality and representation, the gentleman in front of us, we don't have a face of inclusivity. Does it mean that we didn't have women who could meet the list? Yeah. So sad, very sad.
Even as I was moving the podium, I half expected that. That question isn't for these guys. Marcus, where are you? It's not even for me. Brenda, yeah. Please answer that question.
So we try to invite as many, and balance the gender. As you can hear, some of them are representing leaders from the organizations who are women who chose to send gentlemen in their places. And like I was mentioning, we have Honorable Lydia from the judiciary. If you'd like to see, some floral arrangement on the stage, because women beautify spaces, I would request that hopefully for the questions for JCE, we can also have Judy take some. And of course, I had to hand over to my senior, because a good dancer must know when to leave the stage at some point. Asante. Yeah. 3 of them are representing women who are invited here today. So we must check with our people.
Okay, guys, the question has been asked, an answer has been given. We know how we got to where we are now. Let's take this as a lesson. I'm sure ELOG and the partners who organize these are listening. They will do things differently next time, okay? Where were the other hands? Yeah, could somebody give him the mic, please?
Thank you so much. Good afternoon.
Good afternoon.
My name is Salim Ali from Coast, Kilifi County, Malindi. My question, or is just a concern, ambayo inaelekea kwa either judiciary ama IEBC, but wote tu, it's about the tides. Once judiciary kama inafanya case, a petition concerning an election, especially katika ambayo inahusiana na water bodies, nitaangazia hasa kuhusu baharini kule, huwa tunaenda na tides. Kuna low tide, high tide na spring tide. Kinyume na IEBC walipopanga date ya election, hawakuconsider tides ambao wana deny wananchi kupiga kura, hususa jamii ya wavuvi. Kuna wakati mvuvi anatoka baharini akitegemea naenda kupiga kura, lakini
ngoja kidogo ndugu. Naambiwa ya kwamba kuna watu ambao wanatusikiza kwingineko ambao Kiswahili chao si kizuri kama changu na chako. Jaribu uongee Kimombo.
Okay. So IEBC didn't consider the issue of tides. And that is why a certain marginalized community like fisher communities are being denied to get a chance to go and vote because of lack of public participation wakati when the IEBC wanachagua date ya kupiga kura. So judiciary ndio iko pale mbele IEBC, they will also answer that. Wakati when you are handling your petitions on cases, especially petitions about they are coming from the water bodies, do you consider tides wakati mnafanya hizo kesi zenu? Thank you.
Thank you. I think because we didn't set clear guidelines for the questions, that will be answered. But can the next person who has a question or a comment focus on elections? Because if we ask the judiciary about everything they decide on, I think we'll go out of the scope of this meeting. But because the question has been posed, it will be responded to. You are next.
Good afternoon, everyone. Okay, my question goes specifically to the Judiciary Committee on Elections. Okay, I remember you said very well that you held 13 meetings on election dispute resolutions. Thereafter again, you've also held other meetings on, that is the dispute management cases, to see how they are being the issues are being arbitrated. So my question to judiciary is this. I once asked it to Justice Msaga Bongoli, but he's not here, or I don't know whether he's still in the JCE committee. On what basis? Because IBC's the judiciary is trained on, that is, dispute resolutions, and then now case management. And I recommend Felix under when Felix was still in ASA, there's a lot of literature books they gave on case management studies on elections. So at what point, because JCE falls under the direct leadership of the Supreme Court Chief Justice of the country, at what point does Supreme Court gives out advisory on a matter before court? At what point does the Supreme Court give an advisory on a matter before court? Or do you adjudicate on the dispute before court? That comes about what you said regarding Honorable Speaker Moses Wetangula. The Supreme Court finds that this man is guilty of this offense. Then the Supreme Court is going to give another report so that this matter starts now again from the magistrate court going upward, whether this offense was really committed. So at what point does the Supreme Court give opinion, give advisory, or do you arbitrate on the dispute before court?
Thank you.
There's this issue which was one of the petitions in the Supreme Court. It was taken in by LSK and it was dismissed. Regarding the ruling in 2013 of the votes cast, what is the meaning of cast? Because the most important person in the elections management is that unknown person called presiding officer. The moment the presiding officer closes polling, the KIMS kit already gives us the voter turnout at this percentage. When this matter gets to the Supreme Court, they say no. These people, since they didn't indicate a proper mark, giving a proper preferential candidate, these people, they never casted their votes. So why did, okay, this is a committee issue which you can maybe submit later on. Why did the Supreme Court dismiss the LSK matter over it? Because I believe Supreme Court can sit again over the matter and they can either review it and dispense with it.
Thank you.
Lastly to
No. I think you've overshot your quota. I said one, I've allowed you two. Could you send the other one by WhatsApp? In fact, there's one that has arrived by WhatsApp that I will put into the common pot. These are the decisions we have to take to make sure we deal with both substance and process, okay? There was one other hand there, yeah. I believe that's Wanza. No? Please proceed.
Wamesema tusiongee Kiswahili, lakini mimi nitaongea Kiswahili sababu ni lugha ya taifa. Na hata kuna mjadala huko inaendelea kwamba Kiswahili kisikizwe. Na hata mkitoka hapa mtaongea Kiswahili.
Ngoja dada Tumekusikia. Sasa uliza swali.
Nauliza swali. Swali ni kusikitika, tangu asubuhi mnamwaga kizungu, hamupitishi Kiswahili ndani. Na nilikuwa na hofu ya kwamba wale wenzangu kutoka Mombasa huwa tukikuwa pamoja huwa wanapitisha ndani Kiswahili. Na leo sijui imekuaje. Hai suruache niende. Swali langu la kwanza ni kwamba nauliza IPOA. Kama kuna wale watu wa IPOA kama wako hapa. Nauliza swali limenisumbua kwa muda mrefu. Na linanikera pengine na yule mwingine. IPOA ni watu wazuri. Lakini wakati mtu amepata shida ama amepigwa na askari, unasikia tunaenda kwa IPOA. IPOA wanafuatilia, lakini mwishowe hatupati majibu ya IPOA. Watu wanaumizwa na tumeweka hapo kitu kinaitwa IPOA. Hii IPOA huwa inafanya nini? Inaniumiza mimi na yule mwingine mkereketo wa chini.
Swali la pili.
Sasa si la pili. Hiyo ilikuwa inaniumiza tu kwa ajili ya IPOA, naomba wanijibu. Na swali lingine, na nikushukuru. Mimi nafanya na ELOG. Ndio sababu nimeingia kwa IPOA. ELOG, wakati tuko mashinani tumesimamia zile kura, huenda huyu mtu hajafurahia kazi tumefanya, anatusukuma, hata tunapigwa. Tukitarajia IPOA itatusaidia. Lakini wakati nasukuma hatuoni penye IPOA inatupeleka.
Sawa. Kwa vile sasa umeanza kujirudia, nitaenda kwa mwingine. Muda umeyoyoma, hatuna muda.
Nashukuru tu kwa kazi yenu, lakini nasema hivi, tushikane ili tuweze tukakomboa Kenya.
Sawa.
Mwanzo lisikuwe mwisho. Mungu
asante sana. There's 2 more hands and then we are done. So that corner and then that corner.
I can take. Thank you very much. I'll be very brief, Bwana Ayua. I'll ask 2 questions kindly. One, this goes to Mlochi and our good friend from the Kenya law.
If they are going to be 3, they have to be short. Huh?
Just 2 and very short, I promise. I was mentioning Bwana Mlochi and a friend from the Kenya Law Reform Commission. The issue of public participation. What is the threshold? Because of late, courts are saying there was no participation. So how do we determine this threshold for participation? The second one is, all of us appear to be glorifying the campaign financing law. I'm wondering how many of you know the amount of money that was allocated to the seats. If you are running for president, for example, you need 5B. And calculating the salary of the president of this country in 5 years, you can't raise 5B, surely. Even as we need the operationalization of that law, can't we relook at what was set by IBC in terms of what you require? Thank you.
Thank you. Finally.
Thank you very much. My name is Francis Kea. My question is to the civil society. We have failed this country. You know, we cannot succeed through hotels. We need to come up, because I believe that civil society have a lot of money. We can even have our own TV. We can have our own Nitaling center, whereby we can tell the community or the wananchi, we can tell the wananchi, this is the correct figure we have for civil society. We don't need to rely on governments, institution, because that's why we fail our own community on the ground. So we need to come up with because I believe we are able, we are professional people. Let's not rely on government institution, please. Let's civil society stand for the wananchi, because we are third eyes in this country. God bless you.
Thank you very much. So I believe, and if I've left out anything, please, those who have asked questions, please remind me. We've got 8 or so. For an efficient process, I think we will dispense with the easy one. So the manel, I believe that's what it is called. We have learned. We will do things differently, is what I think you can take from what Brenda said, and the leadership of ILOG as well. Mambo ya Kiswahili, nadhani wenzangu pia wamewasikia, but I was given instructions that there are people who are following online and they have issues with Kiswahili. So I think next time, basically what we do is organize it in such a way that we deal with both languages, because I think the reason everybody was clapping is we've got 2 official languages, isn't it? Actually 3, English, Kiswahili, and Kenyan Sign Language. Sio? So we've had you on that one as well. So now let's go to the meat of the matter, the judiciary. This one I have allowed it, I've taken moderator's license. Petitions from water bodies. Is that for you, Edwin, or is it for your colleague, Lillian? Go ahead. Where's the mic? Yani maswali yameisha mkatupa mic. Hii ni yangu. Yeah, give him that mic.
Thank you very much. Now, your question is that do we consider tithes in making decisions in EDR matters? Now, you see, cases are brought to court by either lawyers or parties, parties or their representatives who are lawyers. And once a case is, niongee Kiswahili? Okay. Wakati kesi inaletwa ndani ya mahakama, inaletwa na wewe ama wakili wako. Na kazi ya hakimu ama jaji ambaye ako pale ni kuangalia ile kesi yako ambayo umeleta. Kama uko na issue na mambo ya wakati wa kupiga kura, tuseme ya kwamba kituo kinafunguliwa saa 12 na kimefungwa saa 12, na unaona ya kwamba kuna shida pale, intakana uangazie hilo jambo katika makaratasi yako ambayo umeleta mbele ya koti, na ni jambo ambalo utapewa nafasi ulizungumzie, na wakati unalizungumzia mahakama itaweza kufanya uamuzi kuhusu hilo jambo. Sijui kama tuko pamoja. Kwa hivyo mahakama haiwezi anza tu kuamua vitu ambavyo haviko mbele yake, ya kwamba hakimu ama jaji anaamua tu. Nilisikia ya kwamba mambo huko Kilifi, kituo kilifunguliwa saa hii, kikafungwa saa hii, na wavuvi walikuwa wameenda bahari ya mbali kuvua, kwa hivyo pia wacha niamue hilo jambo. Haifanyiki hivyo.
Sawa,
wanaamua kulingana na yale ambayo yako mbele ya mahakama.
Asante Edwin. Swali la pili ambalo pia linaelekezwa kwa JCE, at what point does the Supreme Court issue an advisory opinion versus deciding on a matter before it?
This one I'll briefly talk about it, but I also want Dudley to say something about it. Now, we know that a county government can approach the Supreme Court for an advisory opinion. And the Supreme Court is the apex court in this country. So when it's adjudicating on a matter, they have the leeway to give their opinion. Like if you read the recent judgment in the petition, Raila, they call it Raila 4 or Raila 3, you will realize they are talking, they have rendered themselves, or rather they have given their opinion or their thoughts on what happened at IEBC. The 4 commissioners leaving Bomas and going to Serena and calling the press conference. So they have rendered their thoughts on that. They have that leeway. So I am not a member of that court. I'm a very junior magistrate, but I believe they are the ones who decide when they want to advise, when they want to maybe lambast, for lack of a better word, lambast someone or a certain body, or call for reforms in a certain area. That is actually within their mandate as the apex court in this country. So I may not be able to tell you this is when we decide to do this, because I'm not a member of that court.
Thank you.
Dudley can say something.
No, we are allocating time very strictly. Dudley has his questions coming. In fact, the good one for Dudley is the one on votes cast. Yeah, because this question has been litigated severally. I believe whoever was asking was actually just asking for a retake on that. So if you can go to that, Dudley, please.
Okay, thank you. I think that's one of the issues that came to the Supreme Court through the LSK amicus brief. If you look at the current constitution, it says all the votes cast are tabulated and counted and tabulated. At that point, you include everything that goes into the ballot box, all the votes cast. Then all the votes cast are used to determine the result. The person who is declared winner must have got 50% plus 1 of all the votes cast. But then Supreme Court says, no, we are not going to consider rejected votes. What's a rejected vote, for example? It's someone who, like the vote I'm looking at, says none of the candidates above. You remember there were some candidates who were disqualified. There were some candidates who were stopped from vying. Now suppose that those candidates have their supporters who then go on to make a protest vote. They say that because you disqualified our candidate, we do not think any of the others worthy of our votes. Now the Supreme Court currently treats those voters, whatever their number is, however large they are, as someone who slept. The votes don't count. In other words, you must choose, you must make a choice between the candidates, the 2 candidates on the ballot. You have no right to abstain. You cannot protest against, say, the integrity of any candidate. If you do, then you'd better just stay at home and sleep. That's what the Supreme Court is saying, by insisting on all the valid votes. Now, if our current constitution wanted to use that word, all the valid votes, it would have just lifted it from the previous constitution. Other countries like Ghana use valid votes. Colombia expressly allow you to make an abstention. We just need to relook at that issue again. And maybe the law reform guys are here. There's need to separate the categories of rejection in the regulations, because the regulations place together ballots without security features under rejected votes, or one who ticks all candidates or who rejects all. There's need to bring clarity to that area still. And I think the Supreme Court should be more willing to correct itself. When it corrected itself in Raila 2017 on the disjunctive interpretation of Section 83, it made the law better. But the court never, ever departs. It's only departed once in Raila 2017.
Thank you. I was looking at Felix and I think that one needs a meeting. What say you? Because you also spoke on that same issue.
I fully agree with Dudley on that. And that has been my position since 2013 judgment by the Supreme Court. That if the Constitution wanted to treat valid votes differently from total votes cast, it would have expressly made it so in its Constitution. And we even drew a distinction between the Kenyan Constitution and the Ghanaian Constitution that talks about valid votes in the Ghana case as opposed to total votes cast in the Kenyan case. If in arriving at 50% plus 1, if you tabulate total votes cast and valid votes cast, the threshold is higher in the total votes cast. And I think the Kenyan people and the Kenyan Constitution wanted a higher threshold for election of a president, and hence pitching it to total votes cast as opposed to valid votes cast. So the Supreme Court is, I think, needs to relook at that issue.
Okay. IPOA. Nani atajibu hilo swali? Hawafuatilii maneno. I know we have ICJ in the room. Thuku, do you want to try?
Thank you. Conversations with IPOA have been that, of course, like any other government institution, they are overwhelmed, they are understaffed, underfunded, and have not received the requisite support from the government as they should. And of course, there is the interagency blaming. So you might refer something to IPOA, and they will tell you maybe go to the internal affairs unit. You go to the internal affairs unit, some cases are even referred to ODPP. I think that has been a great challenge, but going forward, it's something that is being worked on, and there is a policy to try and regulate how IPOA works. Thank you.
Public participation is the next one. What is the threshold? Because we've had several laws and other actions being invalidated on account of public participation. For those who haven't spoken yet, if you'd like to volunteer to answer that one, please do so.
Thank you very much. Indeed, public participation is a constitutional principle. And if you look at Article 1 and Article 10, it's like the spirit of the Constitution. We, the people, must participate in governance. And making of laws, of course, is not exclusive of that particular role of making legislation. Even as if we have our representative, we still must participate. The courts have rendered various decisions and thrown out some legislation on the basis of lack of public participation. The question which is being asked, how can we achieve it? If you look at some of these decisions, the court has tried to guide. For example, it has said that it's not mere consultation. So you must be able to engage properly with the relevant publics to be able to achieve what is called public participation. In other areas, they have said that the relevant public must be consulted. Like if you are doing a law on health, probably the best public in that case would be medical practitioners. And you may not call necessarily the people who are on the other side, let's say fishermen, to help you with health matters. So the public also is to be considered. But I want to give the final, perhaps, something for the plenary and for all of us to think. There is a court case, which was, I think, in 1996, known as Rex versus Secretary of State. It's a UK case, but it gave us 3 principles which must be achieved for us to say that is the threshold. One, that you must give people sufficient information. So point number 1 is that they must have sufficient information. The second principle out of that case is that there must be sufficient time, which means you cannot call people tomorrow for public participation today in the evening. So sufficient time. The three principle out of that case, Rex versus Secretary of State, is that there must be feedback to those who gave you, or you wanted to participate, which means you tell the people that we considered option A, which you gave us, and option B, but we did not take your option A because of these and these reasons. So I think those three principles is what I could say enshrines the principles of achieving public participation. Thank you.
Thank you very much. Sorry, I was just consulting with the senior moderator here. We have another question that questions the manner in which we've been talking about the campaign financing regulations. I think this question is about how is it that we take it as a given that it is good law, and therefore we are only thinking about how it should be moved forward. And it was accompanied by a sub-question that says, do we know how much money IEBC had even allocated for the seats? So by way of regulation, it does seem that the thresholds had been set too low. I'm just paraphrasing the asker of the question, and probably they should have been set higher. So who wants to take the campaign financing question?
I'll just make very brief comment with respect to the first limb of that question. Is it a good law? I think there has to be a common understanding that if there is one piece of legislation worldwide that is difficult to implement, is election campaign financing law. The reason is that if you look comparatively across the world, usually ruling parties and the main opposition parties benefit from this legislation. Benefit from illicit funding in the campaign period. And that is probably one of the reasons why this piece of legislation has never found expression in our statutes. It was passed in 2013. First of all, it was supposed to have been passed in 2011, but Parliament decided that they were not touching it. They conveniently passed it after the 2013 election in November, but then provided that it would be implemented in 2017. Now in 2017, both the ruling and the opposition sat together and decided to postpone its implementation to 2022. Again in 2022, they again postponed its implementation. So this is one rare piece of legislation that usually the opposition and the ruling party see eye to eye on. But if you look at all the problems that we have with campaign financing, in the final analysis, I think this is a good law, and it should actually find expression in our statutes.
I think my senior has already answered that one very well, but I must say this. In engaging the stakeholders on the election campaign financing, one of the few things we were able to pick from the public is that especially the youth and women look at capping in a way that scares their participation. That if you're already talking or telling a person that you need to cap at 40 million to be a member of parliament, and that person doesn't have even $1 million to begin the campaign, you've already scared that kind of a person. So there are those realistic, and I think this is something that is done periodically, maybe is to engage IBC properly when they are doing capping. On what grounds are you doing capping? You're looking at the geographical location of an area, you're looking at the modern trends of an election that you need, communication experts, you need a number of IT experts, you need advertisements and all that to ensure that one, the figure that you're capping at is not so prohibitive and scary to prospective aspirants, but also is also not, a free-for-all where you put large amounts where everybody, or rather you limit it and make it look like a rich man's game. So that's what I think, that a proper engagement and participation in the process of developing those capping is very critical for all the stakeholders. Yeah.
Asante sana. I believe the last one was a clarion call. It was a clarion call for us to stop over-relying on other institutions. It went even as far as to suggest we should set up our own mechanisms of parallel tallying. And if that somebody thinks I misunderstood that, please let me know. Because we are running short of time, I would like to retire this panel. Wametosha unga? Thank you very much. So tutaendelea na mtindo huo. I think because this next one is few people, we will not take as long as we've taken this one, even though we tried to be as efficient as we could be in the circumstances. Can I therefore call upon the next panelist to come forward? Araka Matara. Araka Matara. As he comes forward, Angelina Kalabai. On this one, we are looking good, 50-50. Angelina, yuko wapi? Please, njoo ukae pale mbele. One of the participants is joking that you dare not have delegated this to another man. Tembea haraka mama. And it's been a long afternoon. It's a good thing I didn't notice anybody dozing. If you want to stand and just do a brief stretch, you can do so. Tafadhali msiondoke. Hata kama naona wengine wakiondoka, lakini I hope si wengi. This next one is actually about the real issues on the ground. It is about experience sharing. We have two people who would like to share their testimonials with us. And I think it would be a good thing to listen to them. Marcus, do you have anybody else, just so that as I manage time? Is Marcus in the room? He stepped out. Okay. So then we'll proceed on the assumption that it is just these two, and we can ask them questions, and then we'll move forward. Angelina is an ELOG observer. She was working in Trans Nzoia in the last elections. And I think you've heard her well enough to know, akitaka kuongea kwa Kiswahili tutamruhusu aongee kwa Kiswahili, si ndio? Haya, hiyo nimemaliza. Araka Matara, on the other hand, is a KCA board member. KCA can mean many things. I believe this is the Kenya Correspondents Association. And a KBC journalist, also sharing some perspectives from the trenches. Where is that mic? Nani amechukua mic tena? Ama panelist mmoja alihepa nayo? We have to sort out this mic scandal. It is here. Okay, you start us off, Araka. You've got 10 minutes. No, just speak while you're seated there. We tend to overrate these things. Let's keep it conversational and fast. 10 minutes, beginning now.
Good afternoon, participants.
Good evening.
Yeah, mine is an experience that I'm going to give out here. Over the years, we have been working in Nyanza region. Members of the public look upon the media to inform and educate them about matters, elections, when it comes to the electoral cycle processes. For the first time in history, we have had a group of our members covering the elections for the first time. Some have not been trained, but they have learned on the job, and therefore they face challenges. For example, they have always been accused of misleading or disinforming the public on election matters when they cannot report accurately on, for example, nominations. When does an aspirant become a candidate? Is it during the party primaries or the IBC nominations? They have also had challenges on covering court petitions. In the media, covering court proceedings is a specialized type of reporting, and one has to be appraised on it. We have had cases where even candidates who lose in the elections petition that a journalist covering the elections be ordered to give evidence on the work he did. That one has happened, but we requested that if it is the order of the court, the evidence be given in camera. But that was the first time for a journalist to be ordered to give evidence on a petition. At the end of the day, the judge ruled that the evidence was not substantive. There is also another issue where journalists reported that because the running mates of certain candidates, that is gubernatorial, for the gubernatorial seat, had stepped down, therefore they have quit the race. But the same candidates proceeded to the ballot. Another interesting case was where journalists could be given some lifts by certain candidates and be expected to report objectively or factually. In the process of doing their work, we have encountered the following: physical, emotional, and even online threats and assaults, sometimes leading to the death of one of us. The question is, can a journalist be persecuted for reporting objectively or in a balanced manner? Our association has therefore embarked on a rigorous process of trying to train these members who are ill-trained to verify their information using certain tools. We have done this through in-house training and even training from the regulator. The last question I'll pose is, can a journalist be held to account for not informing the public on matters elections, even when he is poorly remunerated, is poorly equipped? I rest my case.
That was short and sweet. I didn't even have to figure out whether the minutes were over. They weren't. Mama Angelina, tafadhali dakika 10.
Ni sawa.
Haya.
Nitarudia tu kwa sababu nilikuwa nimeongea pale. Kwanza ninashukuru ELOG kwa sababu nimefanya nayo kwa muda mrefu sana. Nilianza nayo 2010 mpaka wakati huu. Uzuri wa ELOG ni kwamba wanafanya na yule mtu wa chini, mlemavu, wote. Mradi tu anaweza kuwajibika kufanya hiyo kazi. Ndio sababu tunapenda ELOG kwa sababu imetusaidia mashinani. Sasa shida ya kubwa ni ELOG wako hapa Nairobi na hata huko wako. Lakini hii kitu ambayo inaitwa IPOA, ninarudia kuuliza, huwa inasukuma mambo haya yanafika wapi? Hata na nyinyi wenzangu pengine mmeona. Pole sana ninapowaingilia, lakini ninasema kwa ukweli, sababu hiyo ndio iko karibu na mwananchi. Wakati mwananchi ameumia ama ameuawa, mimi huwa naona kwa TV. Hii IPOA inafuata, mwisho hata sioni imetoa jibu gani. na ndio tumetegemea kitu kinaitwa IPOA. Wananchi wenzangu na IPOA yenye iko hapa, tafadhali kama kuna mambo mengine mnataka waongeze, mseme tuwaongeze, hata sisi tuwasaidie huko, ili tuweze tukasaidia watu ambao wanaumia na wengine wanazikwa na inaisha hivyo. Tukitegemea IPOA itatusaidia, na mwisho hatuoni penye IPOA inatupeleka. Kwa hivyo uchungu ni kwamba hawa watu wetu tunaangamia na hatuna msaidizi. Ukweli tunaangamia huko mashinani, tunaangamia. Wanaweza kufanya hivyo, waende kwa mzee wa mtaa na mambo yaishe, tukingoja IPOA. IPOA inakuja inaandika, baadaye inapotea. Pole nikiwaingilia, lakini nasema ukweli. Na neno la mwisho, wananchi wenye mko hapa, hii kitu tulianza wakati ule mwingine, na hata serikali ilikuwa inatuogopa sababu sauti yetu ilikuwa ni moja. Tungeweza kuongea Mombasa, tuongee Mara, tuongee hata huko Trans Nzoia, sauti yetu ilikuwa ni moja. Mimi ninasema ya kwamba kama tumeanza hiki kitu leo, wacha sauti yetu ikuwe pamoja, ili tuweze tukasaidia yule Mkenya mnyonge. Huko chini tunaumia. Tunapokuja hapa tunaleta mambo yetu tukasikizwa mpaka na yule mtu mwenye ako chini. Ni hayo tu, sina mambo mengi. Angelina kutoka Trans Nzoia hilo.
Asante sana Angelina. Kwa vile tunarudi upande wenu kwa maswali na mengineyo, nitasihi mtu mmoja aje achukue hiki kidude apatie wanaotaka kuuliza maswali. Why are you laughing at my Kiswahili? Kidude is also a Kiswahili word. I don't know what a microphone is called in Kiswahili, so I'm doing as good as I can. Kipaza sauti. Good. See, you learn a new thing every day. Okay, ni wangapi wako na maswali ama wangependa kusema lolote juu ya mambo ambayo wenzetu wawili wametuambia? Okay, kuna mmoja pale. Please proceed.
Okay. Yes, hello everybody. I am Domi Yambo Dote from Development Through Media, and we are also running Radio Baraza. And I think it's an online station that is specifically purely a non-profit radio for civil society. You know, these things we are saying here, and I've been listening here 2 weeks. On Friday, we had another session somewhere else. And all these issues are similar. We are talking about issues of independent institutions as contained in the Constitution. And I dare say that most of those independent institutions are being run by people who are in civil society. And there's that context in everything, or for everything. We are here running independent institutions, and there are people who believe exactly what it is that we've been discussing here. Joshua, my friend, is here. And my question is then, what have we contributed to this current situation? We as members of civil society, because we go to institutions and we know the reason why we fought for those institutions, yet the JSC or whatever it is doing exactly what it is that we don't want them to do. Can we also point inwards and wonder to ourselves, what is it that we are not doing right? And we need to ask ourselves those questions. Otherwise, it's not just government all the time.
Thank you, Domi. Kuna mwingine ambaye ana swali ama angependa kuchangia hayo maneno ambayo yamesemwa? Going one, going two. Haya, kuna mkono pale umeinuliwa. Keep your hand up so that the mic can find its way to you.
Yes, my name is Mwangi Muraya, na nikiongea ile maneno ya Mama Jedida ambayo anasema hapa, ni kweli wakati mwingine ripoti ambazo zimeweza kuwasilishwa katika kikao cha leo sana sana zimetokana na wale observers ama monitors ambao walikuwa mashinani, na wakati mwingi wale watu wanajipata matatani. Kwa mfano pale Nakuru, wakati tulisema kulikuwa na mauaji ya kiholela ya askari, tulipokuwa tunaenda kudocument yale maneno pale, ungeona hata waziri mwenyewe akionyesha kidole wale watu ambao walikuwa ni monitors ama human defenders akisema nyinyi na tukiua hapa huo mdomo wenu muondoe hapo. So hayo ni masuala muhimu ambayo sheria, kwamba kuwe na sheria na wakati tunafanya uchaguzi monitor ajulikane yako, human right defender ako pale, kwa sababu wengi wao wanaishia hata kuuliwa na wengine hata kuhama manyumbani kwao. So nadhani ni muhimu hilo swala liweze kuangaziwa. Na pia niseme ya kwamba nimesikia mwenzangu pale akisema kama sisi members wa civil society si nini tunafanya. Nadhani sisi tunafanya kila jitihada kuhakikisha ya kwamba uchaguzi wetu nchini Kenya utakuwa kielelezo katika bara la Afrika. Juzi tulikuwa na mkutano pale Nakuru, naona mtu kutoka pande ya Ethiopia anasema kama kuna taifa ambalo linapea Afrika hope kwamba uchaguzi siku moja wa Afrika watakuwa kimwaga damu ni Kenya. Na akasema ya kwamba anafurahia jinsi civil societies hapa Afrika haswa Kenya vile ambavyo tumeweza kujituma. Vile ambavyo mimi ningesema ni kwamba tusirudi nyuma, ile nafasi ama ile space ambayo tuko nayo tunaweza adhiri uchaguzi wa haki, tusirudi nyuma na tuendelee kuleta mabadiliko na siku moja nchi yetu itaweza kusimama.
Asante sana. Kwa hivyo maswali nadhani ni swali moja tu, sababu jambo la IPOA tumeliongelelea hapo awali, na aliyeongea mara ya mwisho pia amesema sisi watu wa civil society tunafanya vilivyo. In fact, we are a leading example in Africa. So nitawaomba wenzangu ambao wamekaa hapa mbele, kila mtu dakika moja kujibu hili swali. Ni nini ambacho tumefanya kusaidia ama kuchangia hali ilivyo iwe nzuri zaidi? What have we done to contribute to the current situation? But I believe, Domi, you are also worried about what we have done to improve things so far. Good. Tuanze na Angelina. Hiyo mic iko wapi? Mpatie Angelina. Ni nini ambacho tumefanya kuchangia hali ilivyo saa hizi kufika ilivyo, na ni nini ambacho tunaweza kufanya iwe njema zaidi?
Kitu ambacho tunaweza kufanya iwe nzuri zaidi, kongamano kama hili ambalo tunalo leo, kama ingewezekana lifanywe mara kwa mara. Nafikiri ni hivyo, na zaidi kufuatilia yule mtu mnyonge ambayo ako chini, hajui atapeleka wapi mambo yake, hasa wakati huwa ya kura. Tufuatilie ndio tuweze tukasaidia Kenya yetu pia kufuatia kwa wale ambao wako chini wanyonge. Ni hivyo tu.
Yeah, I think we can consider ourselves as maybe, as the media, having committed some sins of omission and commission. One, by not reporting accurately and therefore causing some confusion. And two, by assuming that our role should be left unquestioned. But we have taken steps, as I mentioned here earlier, that plans are underway to train journalists on how to report accurately by verifying the information they receive through some identified tools, or that is facilities.
Asante sana. Wanapoondoka jukwani tuwapigie makofi tafadhali. Haya, tumefika tamati. But in the old days there was something called summing up. So acha nione kama naweza fanya haraka haraka. Maka sio wape. Kwa vile hayuko nikimaliza nitampatia Alingo. But because I am likely to forget, CRECO members, once we are done with this current session, please meet outside at the gardens after this. If you're not sure where the gardens are, fuata Joshua. Tumeelewana? Haya. Today's sessions were this afternoon's sessions, sorry. And we began with a session discussing the legal framework for elections and asking the rhetorical question whether they are the reason why we continue to struggle. Quite a number of things have been said. I don't wish to go through all of them for want of time. But there are a number of things that I think we are called to reflect on either today or in the days to come. One of the things that was mentioned is the lack of regulations for the Election Campaign Financing Act. I dare say that if some of us in the room have problems also with the content of the Parent Act, then I think it is up for discussion as well as a reform measure. But those who spoke severally about the lack of regulations. The draft regulations were pending before Parliament, but for one reason or other, they were not adopted before we went to the elections. The next thing that was mentioned was the fact that we don't have a referendum law. Again, there's a draft on this, and it's just a question of polishing it if necessary and taking it through the measures necessary to legislate. There's no law to guide the country on boundary delimitation. Never mind that we have around, I think, 2 years to go before we run out of the deadline for doing that. I believe the last review was done in 2012 by the Isaac Hassan team. It was a carryover from the work that Legales Commission was wound up not having finished. And now we are at the 10-year mark. So we've got another 2 years or so to go through what is a very political issue. And one of the panelists said, that was Mr. War, that we don't have laws to guide that process. The other issue that also came up is the need for the voter registration process to be relooked. It's got issues that are about the politics of the process, but there's also possibly some need there to relook the law. And this tied in with, so for instance, what was being said, I think this was by Thuku, that we had a comprehensive report by KPMG, but then we only got excerpts of it. And even then, quite late in the day. So another comprehensive take at what it will take to get good voter registration is part of what is on the table. The next is the results management process, which again we have fine-tuned over time. I can take license to say that it is much better than it used to be, but it still has issues. As a result of those issues, we have people sometimes toying with the fact that we should just go back to the manual system. The question was posed whether we should have the technology-enabled system, but with a complementary way of figuring out how to make sure that there's no technological malfeasance. What I was alluding to that came by way of WhatsApp was the possibility of also using blockchain technology, but the question still had some other questions around it, which I think we will pass into the organizers of the conference. But there's something there about results management. And this is typically one of the areas where the process then collapses. Everything is good. The preliminary reports of the observers will have said Kenyans voted peacefully and so on and so forth. And then the process breaks down at that stage. Electoral dispute resolution, there was a lot said about the language of the court in the media. I think that's found its way here. And then there's the question of the standard and burden of proof, which again has been litigated severally, but we are still looking for ways of resolving that. The timeline for resolution of election disputes, I think it's been said that 14 days are not enough. But that then begs the question, what will be enough? I think what we need to do is to strike a balance, because also you don't want a dispute over the presidential elections taking too long to resolve. But on the other hand, we've had 2 experiences with a 14-day period. Actually, in 2017, we had 2, and in 2013, we had 1. So we've had 3 experiences, and then we've had the experience of this one. Yeah, so those are 4. We've had 4 times to go through this 14-day high-pressure litigation, and what panelists were saying is that we would like to revisit it. The disputes arising from primaries, the role of IEBC, especially sitting in to hear disputes that arise from things that its own officers did. But there's also the question of how you make sure that this is handled in a way that ensures it doesn't delay the processing of election materials like ballot papers. And I think that was one of the problems this time as well. We've got questions of Section 75 of the Elections Act and the appeals and the 6-month deadline. Again, these are timelines again. The campaign finance regulations that I have already spoken to. The question of election offences. I believe when Parliament removed them all from the Elections Act, they took us back to the regime we had before, where there was an Election Offences Act, but there may be things that haven't been dealt with. In fact, for me, part of the reason campaign financing is a bit of a hot issue, and Thuku was alluding to some of these, I think, when he was speaking. Usually, you've got people tagging on the one hand, trying to have as high a threshold as possible, and then you've got those who are trying to have as low as possible, like the youth, not moneyed, and so on. I believe in the end, we'll have to find a balance between those extremes, and finding a balance on the higher side means we take out also some of the things that are usually in those budgets, but which are not legitimate election expenses, like money for paying goons. I can go on and on. So I think that's the balance that we are going to have to strike. The DPP, yeah, why report to the DPP to investigate? I think this feeds back to the question of the standard of proof, because if you want the process to run in such a way as soon as there's a judicial determination on the basis of all the evidence, it could well be that if there are election offenses, the court should just pronounce itself on those issues. But if the DPP has to get a report and to investigate and to begin a new process, that's the reason we've been having some of the debates we continue to have about the standard of proof. The conflicting judicial decisions and these electoral cycles, so some, also that's an issue that the panelists were saying we need to attend to. There's the commercialization of politics. I think that takes us back to campaign finance. There's the question of access to information. I alluded to that in terms of the voter register. There's a need to find a way to manage the social media. Yeah, this is one of the things that Otachi spoke to, because on the other hand, on one hand, this is the age that we live in. Information now flies at the speed of thought, but that can be a good thing, and it can also be a dangerous thing. The Leadership and Integrity Act, I think we've set a low bar already, and it seems to be going even lower. I think we were saying that that needs to be revisited as well, because the Constitution, I think, set quite a high bar for integrity in leadership. The statutory framework is not matching. Intersex persons' participation in elections is the other thing that was all. Election financing, that has been spoken to. The Political Parties Amendment Act, I think that had quite some debate running into this year's elections. There may be issues there for revisiting. The Election Amendment Bill 2021 and some of the litigation around this, also in regard to election educational qualifications, an issue that also came up that we might need to revisit. And then there was the relationship between IEBC and Parliament. I believe those are the issues that came up and which were presented on and then were clarified in the question and answer session that we had. We also had opportunity this afternoon to listen to 2 of our colleagues with some feedback from the trenches. There's obviously things that need to be attended to in terms of equipping journalists to do a better job. It is better listening to Araka than it used to be before, but it can be improved. And I think he does raise a number of other things that we need to reflect on, such as the training of journalists is one thing, but the working environment that they have, poor wages and all, is part of what I think he reminds us we need to take care of if we are to end, is it called brown envelope journalism with regard to elections? So that's one of the things that I got. And then, of course, it's a pity that we didn't invite our friends from IPOA here, but I do believe in the context of some of the things that happened during the election cycle, including some people being killed, there's questions not just about how IEBC is doing its role, discharging its role, but also how sister institutions such as IPOA are discharging theirs. Because ultimately, IEBC is the principal election management body, but it does not deliver on that mandate alone. There's a number of other agencies that also play supportive roles, and we need to worry about how well they do that. And then to celebrate ourselves as civil society for the work we've done in the context of elections, but to know that there's still more that we can do. We can do better. We shouldn't rest on our laurels, is part of what's also being said. And Marcus is here, so instead of dropping the mic, I will hand him the mic. I thank you very much for listening.
Thank you very much, Francis. I'll be very brief in terms of what we need to do tomorrow. So tomorrow we start at 8:30 a.m., not at 9 a.m. as indicated in the program. So I'd like to request all of us to be that we can be able to discuss a number of interesting topics tomorrow. So tomorrow we're discussing a number of issues in terms of accountability in elections, in terms of leadership, in terms of peace, cohesion, the role that the church and faiths have continued to play in this election. Tomorrow again we shall be discussing a very interesting topic on political parties and some of the issues that were raised in terms of election campaign financing. We have a very big discussion tomorrow again relating to the participation of special interest groups. We are looking at the whole spectrum, the groups outlined in Article 100 of our Constitution. And also, of course, a discussion around the place and the effects of fake news, misinformation, disinformation, and how the media has continued to cover our electoral process. So we want to entice you by saying these topics mapema. We request that you keep time tomorrow. Please be here in good time, 8:30 we start our sessions. I have two announcements to make. Tea is served. So after we declare the meeting closed for today, then please walk out there and serve yourself some cup of tea or coffee. I would like also to invite the rapporteurs, the Uzi leaders as well, and the technical team members to a very short debrief session in the room that is just adjacent here where the printing is taking place. Without wasting much time, I would like to thank each one of you on behalf of the team that is behind what we are seeing here today. That we will be live even tomorrow again. Continue following us, tweeting and retweeting what we are doing here today. Thank you for your time. We hope and looking forward to seeing you tomorrow. Ensure that you have a bag. There's a bag being given out there. Please take your bag and we will come back tomorrow. Very well. Thank you guys. See you tomorrow. Oh, and by the way, Francis and Peter, part of the short debrief.